When is discrimination not discrimination? While the Sixth Circuit Court of Appeals would have you think that reverse discrimination is not only legal, but okay. However, discrimination is discrimination, even when it's used in an attempt to right some past wrong. So we'll look at the case of Ames versus Ohio Department of Youth Services opinion next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your rising generation to be free. I'm glad you could join me today. You know, the question of reverse discrimination has been around pretty much since they figured out discrimination was bad. And I've been seeing it for decades. But a recent Supreme Court opinion says that reverse discrimination is still discrimination, or kind of. There are some details to the case that we'll get into, and I'll talk a bit more about the website and other ways you can get involved at the end of this episode. But for now, let's take a look at this case about reverse discrimination. I wrote about the oral arguments in this case in my article, Heterosexual Discrimination. The question argued before the court was simple, if not straightforward. Did a heterosexual person need more proof of discrimination than a homosexual one? As a refresher, we read from the opinion, Petitioner Marlene Ames, a heterosexual woman, has worked for the Ohio Department of Youth Services in various roles since 2004. In 2019, the agency interviewed Ames for a management position, but ultimately hired another candidate, a lesbian woman. The agency subsequently demoted Ames from her role as a program administrator and later hired a gay man to fill that role. It appears the management at the Ohio Department of Youth Services had it in for heterosexual women. This led Ms. Ames to file a lawsuit. Ames then filed this lawsuit against the agency under Title VII, alleging that she was denied the management promotion and demoted because of her sexual orientation. The district court granted summary judgment to the agency, and the Sixth Circuit affirmed. The courts below analyzed Ames' claim under McDonnell Douglas Corp. Versus Green, which sets forth a traditional framework for evaluating disparate treatment claims that rest on circumstantial evidence. At the first step of that framework, the plaintiff must make a prima facie showing that the defendant acted with a discriminatory motive. Like the district court, the circuit court held that Ames failed to meet her prima facie burden because she had not shown background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. The court reasoned that Ames, as a straight woman, was required to make this showing in addition to the usual ones for establishing a prima facie case. So both the district and circuit courts claim that even though she showed a prima facie case, as a straight woman, Ms. Ames needed to show more than just discrimination. The court called it the background circumstances rule, but the gist of the rule is that discrimination against heterosexuals or other majority groups is easier to get away with. Ms. Ames appealed the circuit court's opinion to the Supreme Court. Now, what is this background circumstances rule the Sixth Circuit relied on? The question in this case is whether, to satisfy that prima facie burden, a plaintiff who is a member of a majority group must also show background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. The rule states that when a member of a majority group, i.e., not a minority, makes a claim of discrimination, they must show a background of circumstances to support their suspicion. In other words, they must show a history of such discrimination. That sounds like reverse discrimination to me. Now, after hearing oral arguments and doing their internal debates, the court came to the following opinion. Held, the Sixth Circuit's background circumstances rule, which requires a member of a majority group to satisfy a higher evidentiary standard to prevail on a Title VII claim, cannot be squared with the text of Title VII or the court's precedents. According to the court, this background circumstances rule cannot square with Title VII or the court's precedent. We find the relevant text of Title VII in Title 42, Section 2000E02 of the United States Code. Under employer practices, it shall be an unlawful employment practice for an employer to fail or refuse to hire or discharge any individual or otherwise discriminate against an individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's color, religion, sex, or national origin. While the law is well beyond the constitutional powers vested in the United States, it is the law that the court was evaluating since it was the basis for Ms. Ames' complaint. The court claims that the Sixth Circuit decision does not square with the text of Title VII, so they remanded it back to them for further review. The Sixth Circuit has implemented a rule that requires certain Title VII plaintiffs, those who are a member of majority groups, to satisfy a heightened evidentiary standard in order to carry their burden under the first step of the McDonnell-Douglas framework. We conclude that Title VII does not impose such a heightened standard on majority group plaintiffs. Therefore, the judgment below is vacated and the case is remanded for application of the proper prima facie standard. It is so ordered. While I believe the court came to the correct decision, they did miss a couple of things along the way. Now, Justice Thomas wrote a concurring opinion to which Justice Gorsuch joined. In this opinion, Justice Thomas pointed out two serious problems missed by the court. I join the court's opinion in full. I write separately to highlight the problems that arise when judges create atextual legal rules and frameworks. Judge-made doctrines have a tendency to distort the underlying statutory text, impose unnecessary burdens on litigants, and cause confusion for courts. The background circumstances rule, correctly rejected by the court today, is one example of this phenomenon. Justice Thomas found the first problem right off the bat. When judges make doctrine, they tend to distort the actual law. These doctrines have the nasty habit of being treated as if they were law, which is the other problem Justice Thomas found. While interpreting and applying substantive law in the essence of the judicial power created under Article 3 of the Constitution, that power does not encompass the making of substantive law. As I so often say, courts do not make law. In fact, they are prohibited from making law because the Constitution vests that power solely with Congress. From Article 1, Section 8, Clause 1, we read, "All legislative power herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." I just wish Thomas and the rest of the justices would recognize that fact. In fact, I wrote an entire section on the topic of judicial hubris in another article. One example from that case is...
No, but we don't, because the argument here is that the president is violating an not just one, but by my count, 4 established Supreme Court precedents.
Except court precedents are not law, so they cannot be violated. Similarly, the Sixth Circuit's background circumstances rule is another example of a judge-made rule distorting the law by elevating judges above it. Unanimous decisions by the Supreme Court are important for a couple of reasons. First, it means the issue should have been rather obvious. After all, if there was a real question about the case, wouldn't you expect at least one justice to dissent? Second, although it really shouldn't matter, the unanimity is often used to give greater weight to those decisions, meaning lower court justices are less likely to ignore them. Looking at the facts of the case, it does seem rather obvious that when the law says it is unlawful for employers to discriminate based on sex, it really doesn't matter which way the discrimination flows. The fact that Ms. Ames had to wait so long, not to mention the cost in both monetary and emotional terms of these multiple court decisions, shows a serious problem with our so-called justice system. As the saying goes, justice delayed is justice denied, and Ms. Ames has been denied justice for more than 5 years, and her wait isn't over. You see, the court didn't award the case to Ms. Ames, but only that her petition that the Sixth Circuit's background circumstances doctrine violated federal law. The court then sent the case back to the Sixth Circuit to try again. I do need to point out one thing before we finish this episode. Title VII, which is Title 42, Section 2000E-2 of the United States Code, is blatantly unconstitutional. Nowhere in the Constitution of the United States will you find the power to regulate employment delegated to it. That means that not only does Title VII violate the Constitution, it is also void. Furthermore, as to the background circumstances rule, I remind people that only Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested in this Constitution by the government of the United States or in any department or officer thereof. Now, while I applaud the anti-discrimination sentiment behind Title VII, that does not make 42 U.S.C. 2000E-2 legal. So this is just another in a long line of cases where the court came to the right answer, but probably for the wrong reason. Agreed that the background circumstances rule doesn't comport with Title VII, and that's absolutely true. It seems the court was more interested in their own precedent than the actual Constitution of the United States, but hey, I'll take the win where we can get it. All this really means is that Ms. Ames goes back to court, and hopefully the Sixth Circuit will look at it and say, yes, she has a discrimination case, and refer it back to the district court. This case is not over for her. But hopefully it's not going in the right direction. Now, if you like this case and you want to find out more, guess what? You can find the article with the links to all my sources on the website, constitutionstudy.com. Now, it's a great place to find not just that, but sign up for the mailing list, maybe buy a book or a cup or a mug or something, or just support the work that we're doing here at the Constitution Study. You can also support our affiliates like The Miracle of America, this great course I found that looks at our history basically from the Pilgrims to the Founding Fathers. It really helps explain why the Declaration and the Constitution were written the way they were. Now, I liked it so much, I made a deal with the owner to get you one lesson absolutely free. Just go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. And you'll be taken to a custom landing page just for my listeners where you can read about the course, read about the instructor, but best of all, enroll for a lesson on God's natural law absolutely free. You get a downloadable study guide and an hour of content, audio or video, whatever you prefer. But you get all of it free. And if you like that and you want to take the whole course, sign up there for just $17.76. But your journey begins by going to constitutionstudy.com/1776 study guide and enrolling for your free lesson today. I also hope you consider Patriot Mobile for your wireless services. They're America's only Christian conservative wireless provider, and they support organizations that are protecting our rights, not those trying to destroy our rights. Go to patriotmobile.com/constitution, find a plan that works for you, see if you're eligible for a discount, then be sure to use the code Constitution at checkout to get free activation. Once again, use your cell phone to protect your rights by going to patriotmobile.com/constitution to find a plan that works for you, and then don't forget that code Constitution at checkout for free activation. Whatever you do, I hope you'll share the content we've put out here today and all the content we have at the Constitution Study. Best of all, I hope you'll bring along a friend maybe next time as you join here for the Constitution Study.